problem is actually the most evident within the small SME market. HR and HR-related matters are usually funneled into an administrator or a finance person, and they're good at that job, but they're not very good at understanding the legislation aspects on the HR side. And the legislation does require a fair amount of study and a fair amount of understanding of what to do and when and why, and what the legal obligations are. So we tend to provide clients with a full service around this HR advisory element within our role as an external HR business partner. We're quick to at least give them clarity on actions they may wish to take, which are not really advisable because there are consequences under the labour law. And this is more apparent now because the labour law had a fundamental change, upgraded and changed after 30 years of it being enacted. So 2022, a big change happened on the labour law. It's the first change after 30 years, and it's designed to keep pace with where the economy is going and to make sure the UAE is a desirable place for employees to work. So there are certain protections and increased protections and different types of visas and working practices enacted under that law that employees can use. But it also gave companies additional powers and additional opportunities for them to make sure they as a company and their assets and security is also protected by employees. So there's been gives to the employees, but there are also been gives to the employer. And the legislation now has created more clarity and understanding of how this relationship works. So it's important to understand that legislation. It's important to think about how to best operate within that legislative framework, slightly differently within the free zone context, very defined under the mainland context, and it needs a good partner to understand how to do this. Internally, some clients face challenges because sometimes it's the wrong skill set trying to understand a different problem, and their interpretation is sometimes not particularly clear. And that's usually the things that we find, particularly in the SME marketplace. The initial problem in misinterpreting the labour law is that the employee has more forums by which to raise some form of dispute. They can go to the Free Zone Authority or the Labour Department, and the Labour Department will investigate and look at these factors. Now, it's not a great reputational benefit for have employees go to the Labour Department with some form of dispute. It requires companies to provide evidence and dispute that case from any employee. And of course, it's not great in terms of your company reputation and brand to attract and retain your talent, which is a key important factor, particularly now as the economy is growing. Good quality talent within your organization is an important asset you want to retain. Any kind of dispute with an employee will certainly circulate, and that's not great to retain your best talent. The Labour Department and forums available to employees are quite available to them, and the Labour Department can investigate, and it can end up in court, and that's not necessarily a great outcome for any party. So having clarity, making sure things are very defined, making sure employees understand your companies and policies, and all the aspects around employee management are well nailed down in terms of formal documentation, agreed and signed and understood, very critical to make sure these sort of issues don't occur.